So also just know in the maintenance court, know which form to complete if there is if there isn't an existing maintenance order as well. That's the J101E if there's no maintenance order in place already. And so that could be either if there is a divorce action but the parties decide that it should be dealt with in the maintenance aspect of the divorce should be dealt with in the maintenance court, and or if the parties aren't getting divorced, they're not married, but they want maintenance, then that's the form that you would complete. Then the court would normally subpoena the respondent, and they would have to bring in the payslip, bank statements, and all of that. And if you want to vary an existing order, you would have to complete a J107E form. Just remember that you would approach the maintenance court for any initial maintenance that you want, for an increase in maintenance, a decrease if your situation has changed, or to stop paying maintenance altogether, to set aside the maintenance order. So these are the times that you would actually attend at the maintenance court to do that. So there's that. Also with regards to your particulars of claim, like I've said, you would specify who the plaintiff is, who the defendant is, the jurisdiction, cause of action, that you were married on such and such a day, in community or out of community. If out of community, you attach those annexures as well, and that the marriage still subsists, that there are children involved, or rather born out of the marriage, and then you specify who they are, or there are no children involved. Don't forget that Annexure A needs to be then attached as well. That goes to the family advocate. If there are children involved, if there's going to be any kind of dispute regarding where the children are going to be residing, or in respect of care or anything like that, then you would obviously, after you see the plea and the counterclaim and all of that, you would then determine whether there's going to be a dispute. If there is, then you would complete another form for the family advocate, which is the Form B, which would, make them go and investigate, and social workers will interview everyone and do a report on who they think is the best interest for the children to be residing with. And then also in your particulars of claim, the reasons for the irretrievable breakdown of the marriage. Don't forget in the Divorce Act the requirements. When would a court grant a divorce? So just make sure that it's in there. And your maintenance, you will discuss maintenance in there as well. Co-guardianship, you will discuss whether you want forfeiture or what exactly it is that you want. And if you want forfeiture, then you have to specify what is being forfeited specifically, and whether a deed of settlement was entered into prior or not. If not, then you leave that out for now. And whether there was a pension fund, if you're entitled to it, because in the divorce order, in terms of the Pension Fund Act, it has to be specifically mentioned that you are entitled to the 50% of the defendant's pension fund. It has to be specifically ordered, so that would also go in there if there is one. If not, you would then leave it out, or if it doesn't form part of the agreement, expressly excluded if you were married A and C including accrual, then you would just leave it out if it was expressly excluded. And then you have your prayers, and you will see at the back of your notes as well the particulars of claim there, and it'll say prayers for forfeiture, and it'll tell you exactly how to plead that, and how to and how to formulate your prayer accordingly. And also, if you're married in community, what you have to ask for in your prayer, division of the joint estate. If there is a deed of settlement, it would be a division of the joint estate incorporating the deed of settlement, and so forth. So that is all at the back of your notes. There is a deed of settlement as well. That's in the back of your notes, which specifies what the arrangement or agreement is. An agreement can be reached at any stage during a divorce, during divorce proceedings. So if the parties agree, then in the deed of settlement you would specify that if an order is made in terms of this deed of settlement, then the defendant would no longer defend the matter, and would no longer defend the matter, that these are the terms of the agreement. You would discuss what happens to movable property. Is it going to be sold? Is one person going to, if the half share going to be transferred to the other party? What's going to happen with maintenance? Is there spousal maintenance? The pension will be noted in there. Don't forget the domcasta clause if there is spousal maintenance. We've spoken about that clause as well. Liabilities, debts, everything to do with settling the matter and waiver, all of that will be in the deed of settlement, which can be done at any stage of the proceedings. So let's have a look. We've discussed all of that. Now, another thing that is very, very important is the interim relief that one can ask for, because sometimes things happen in between, and one party might have funds, and they can go to the High Court, they can get advocates and etc., and the other party might not be employed and maybe was a housewife or so. So you can bring an interim application for interim maintenance, contact, interim contribution towards costs. This is quite it's quite a popular and something that's used all the time. So it is your Rule 43 for interim relief. Please don't forget that this is interim, pending the finalization of the matter. So you can approach court. Remember, it is an application for interim relief. Rule 43 and 58 in the Magistrates Court. It is brought by notice of motion and affidavit. I have seen it asked before when you can bring this kind of application. You can bring it before the issue of summons. You can bring it simultaneously as the summons, or you can do so after notice of intention to defend. So like I say, notice of motion and an affidavit, which the other party can then file an opposing affidavit, and then the matter can be argued, and then a decision can be made by the magistrate or the judge. And this amount, that is, it could be for spousal maintenance, it could be for maintenance for the children interimly, please don't forget that, and it could be for the return of a vehicle or a furniture or whatever it is. More particularly, what's important is the interim maintenance for both the children and the spouse, the interim contact, the interim contribution towards the costs. Okay, that will that will at least alleviate some pressure and give the one party that's perhaps not as well off as the other party some leeway, and allow them to also get legal representation equivalent to, you know, the opponent. So that's the interim relief. Now, in the founding affidavit, you don't forget it's applicant and respondent, because now we're dealing with an application here. And in the interim relief is only in divorce matters. It's not going to be for matters where a client comes in and wants maintenance and is not married. So please just, you know, be mindful of that. This is interim for pending the outcome of a divorce action. The founding affidavit will say who the applicant is, who the respondent is, that the parties were married on such and such a day, and that a divorce action is about to be issued and served, or has been served under this case number, etc., and specify, you know, where the respondent works, how much the respondent earns, how much your expenses are, how much the children require, and that perhaps the respondent you've had these additional expenses that you've had to pay. The respondent has not made any contribution towards the maintenance of the spouse, the children, or costs, and you have to specify what those expenses are and what the respondent is expenses are, and what they are able to what you think they're able to afford. And so yeah, you have to give all that information, and that will then be done away with once the final order has been put in place. So let's say interimly they say that you're entitled to 1,000 Rand a month, and on finalization of the matter they say that you know, the magistrate decides that you're entitled to 2,000. So that 1,000 Rand interim maintenance will then fall away, because now the matter's been finalized and you're entitled to 2,000 Rand, and that's going to be in the order. Okay, so don't forget as well that, like I said earlier, sometimes other matters pop up, you know, so you could, for one divorce, be in the maintenance court, you could be in the regional court or in the high court for the divorce, you could be in the maintenance court for maintenance, you could be in the domestic violence court for protection orders and harassment orders and all of that. So just be mindful of that as well. You could even be in the criminal court for one matter. So that's often it's quite, yeah, it's quite common to be in the domestic violence court, whether it be an application that is brought by a family member, or you against a family member of your spouse. But yes, these applications are quite common. Another thing that is quite important is the substituted service. So we haven't discussed that yet, but I think that you will recall that if a client comes in and they don't know where their husband is, we have to bring an application for substituted service. That will be in the newspaper. So you have to actually bring an application to court, notice of motion and affidavit, asking the court for direction that you can serve via the newspaper where the defendant, or in the application the respondent, was last known to be, or service via Facebook or via email, or to deliver a copy to their parents, or whatever it is. So you can bring that application once again who is the applicant, who is the respondent, the jurisdiction, and then you can specify that what steps you have taken to try and find the person, and that you've instituted action in the divorce, that you want to get divorced, you haven't seen the person for so long, the marriage has broken down irretrievably, and you have to specify that, did you get a private investigator, what happened, and then that application, you will have to ask for the court to grant you a leave to serve it in another manner. So that is that it would have to be put in the newspaper, and sufficient time to for the defendant, or rather the respondent, to come forward and defend if necessary. So that is your substituted service.